A woman, Lily Ledbetter, sued Goodyear Tire and Rubber Company for gender discrimination. She was the only woman working in the male-dominated workspace, and her salary was significantly lower than her male colleagues. This violated Title VII of the Civil Rights Act of 1964, which makes it unlawful to discriminate against someone on the basis of race, color, national origin, sex, including pregnancy, sexual orientation, and gender identity or religion. Ledbetter argued that her low salary compared to her co-workers was due to gender and employee discrimination. This case was granted on June 26, 2006, argued on November 27, 2006, and decided on May 29, 2007.
Lily Ledbetter. It is an honor to be here today to talk about my experience trying to enforce my right to equal pay for equal work. I wish my story had a happy ending, but it doesn't.
When Ledbetter sued Goodyear, the case went to a district court in Gadsden, Alabama. She won the case and received $3.5 million, but the judge reduced it to $360,000. Then Goodyear appealed the case, and it went to the 11th Circuit, and it reversed the lower court, meaning Goodyear won. Since this seemed unfair to Ledbetter, she appealed the case again, and it went to the Supreme Court. Ultimately, she lost to the Supreme Court in both the circuit and SCOTUS. The court argued that Ledbetter missed her deadline, which was a 180-day limitation period.
Ledbetter worked as a supervisor for the Goodyear Tire Company for 19 years and worked as an area manager. By the end of 1997, she was the only woman working as an area manager among her 15 male colleagues. During her two-decade career, she was continuously given low rankings in annual performance and salary reviews, especially compared to her colleagues. Initially, Ledbetter sued Goodyear for the first time in 1998.
Some previous events that relate to the case are the Equal Pay Act of 1963, the Civil Rights Act of 1964, and the SCOTUS case of National Railroad Passenger Corporation versus Morgan. The Equal Pay Act requires that men and women in the same workplace be given equal pay for equal work. The jobs need not be identical, but they must be substantially equal. The Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, religion, sex, or national origin. National Railroad Passenger Corporation versus Morgan was a case argued in 2002. Morgan, a black man, filed a charge of discrimination and retaliation against National Railroad Passenger Corporation.
In United Airlines versus Evans, 1977, the court rejected an argument that is basically the same as Ledbetter's. Evans was forced to resign because the airline refused to employ married flight attendants, but she did not file an EEOC charge regarding her termination. Some years later, the airline rehired her, but treated her as a new employee for seniority purposes. Evans then sued, arguing that while any suit based on the original discrimination was time-barred, the airline's refusal to give her credit for her prior service gave present effect to its past illegal act and thereby perpetuated the consequences of forbidden discrimination.
2 years after the decision of the case on January 29, 2009, former President Barack Obama signed into law the Lily Ledbetter Fair Pay Act. The act requires employers to redouble their efforts to ensure that their pay practices are non-discriminatory and to make certain that they keep the records needed to provide the fairness of pay decisions. To this day, only 7.2% of Goodyear Tire Company's employees are women. Lily Ledbetter continues to fight for equal pay.
The very first bill I signed into law as president was the Lily Ledbetter Fair Pay Restoration Act. It was a big step toward making sure every worker in this country, man or woman, receives equal pay for equal work. I signed this law for women like my mother, a single mother who paid her way through college and made huge contributions to a workforce that wasn't always fair to her.
The Court of Appeals then concluded that there was insufficient evidence to prove that Goodyear had acted with discriminatory intent in making the only two pay decisions that occurred within that time span. Ledbetter points to two different employment practices as possible candidates. Primarily, she urges us to focus on the paychecks that were issued to her during the EEOC charging period, the 180 period preceding the filing of her EEOC questionnaire, each of which she contends was a separate act of discrimination. Alternatively, Ledbetter directs us to the 1998 decision denying her a raise, and she argues that this decision was unlawful because it carried forward intentionally discriminatory disparities from prior years. Both of these arguments fail because they would require us to affect to jettison the defining element of the legal claim on which her Title VII recovery was based.
I'm here to talk about America's commitment to fairness and equality and how people like me and people like you suffer when that commitment is betrayed.